Well, good afternoon, everybody. Welcome to our webinar. I'm delighted today to be joined by BJ Chong, who is one of the managing partners at Palmers and practices in the commercial department. This webinar is all about commercial landlords, as you can see from our title slides. We will be having a questions and answers session at the end of the webinar today. So once BJ's finished his presentation, we'll be happy to take any questions that you have. Can I suggest that you use the Q&A panel, which will be on your Zoom toolbar, to put your questions forward, and please ask away as we go along, and we'll try and answer as many of those as we can at the end of the presentation. So I look forward to hearing what BJ's got to say, and I'll return at the end for the Q&A. So over to you, please, BJ.
I'm sure you would have watched the news last night or read your news feed about the economy being in recession and as a result of the pandemic. It's grim, of course, but let's see what a commercial landlord can do to preserve his or her or its cash flow. Today we're going on a whistle-stop tour of a big topic, how commercial landlords can deal with the legal implications of COVID-19. I'm going to cover some of the main themes which have come into the department over the last few months, and hopefully by the end you'll have some useful pointers so that if you come across them, you'll have something to say and something to do about those scenarios. So the webinar will cover the following topics: rent, or specifically the lack of it being received. What can a landlord do? Using enforcement agents, or what we used to call bailiffs, or the courts when the talking's over and it's time to rumble, I guess. Tenants refusing to reopen, and that can be a concern for some landlords, especially if you've got a portfolio with a shopping centre type scenario or a parade of shops and you need things to be open. Perhaps some scenarios where a tenant can terminate their lease, so what to look out for and what to expect. And finally, for some of you with property which has multi-occupancy, that's several tenants in the same building, what happens if a tenant asks you to suddenly pay or to pay for services or additional facilities to enable a COVID work ready place to be used. So we'll cover some of those and move forward. And as Joe mentioned, we've got the opportunity, subject to time, for Q&A at the end. So let's get started. First slide, please. So can't pay, won't pay. So our kickoff point will always be to look at the lease itself. That's the actual legal document setting out the terms of what the landlord and the tenant agreed up front when the lease was entered into. Now, most modern leases will contain a clause that states that rent is payable without deduction or withholding. So what that basically means is that unless there's some other clause in the lease that excuses or restricts the payment of rent, effectively it's tough cheese for the tenant. You legally have to pay. No ifs or buts usually. Now, as a landlord, if you want to play hardball, that's where a landlord would normally plant their flag, and that's the base you would fight off. But having said that, you would have noticed that during the whole course of the pandemic that, I suppose, the language that's been employed by those in government and others, probably wisely, and I agree with, is that, everyone should work together. It is a very challenging environment for all of us to be in. So what we're dealing with more often than not in this sort of scenario is a tenant seeking some sort of accommodation on rent, which normally takes two forms. The first one is we're not paying rent as a result of either closure or some other issue. Alternatively, a variation of that is, give us some additional rent free. Of course, there are some businesses that still, as of today's date, still cannot open up yet. Now, a few of my clients have in their portfolio some of the larger chain tenants. They've received those sort of requests earlier on when it first we had lockdown. But as we'll see later, there's nothing in the coronavirus regulations that say that tenants should not be paying their rent during this whole phase. The next variation that we'll see from a tenant usually is, please reduce the amount of rent or give us longer to pay. We'll come on to how you'll want to treat those requests, but let's say for commercial reasons, you agree to it. What's really, really important is that the terms of whatever the arrangement, the concessions that you've agreed, or the new instalment are recorded in writing so that everyone knows what's been agreed, and more importantly, your ability to revert back to your full rights as a landlord under the lease are protected. Because if the tenant should not honour their side of the bargain, then you need to know that you haven't abandoned all of your landlord rights under the lease, especially when you're effectively doing potentially the tenant a favour. So moving on quickly to turnover rent. These are rents which are geared to the income of the tenant's business. Often you'll have leases of this sort operating at shopping centres, that type of thing. And what you'll probably see is that that the clause will be drafted so that if income of the tenant's business drops below a certain level, there will still be a floor below which the rent will not fall. Obviously, the point here is that if you have a tenant on a turnover rent type arrangement, well, obviously it's geared towards their income. If the income falls, then the tenant's got grounds to come back and say that's all the rent they're going to pay. But that's contractually locked in by the arrangement that you have there. Okay, so in this COVID-19 environment, there's a couple of things you can do before things escalate. And one of the things I wanted to do really was introduce the code of practice which the government released on the 19th of June, and explain why that might be important in how you deal with the environment as we move through the next couple of weeks and months and so on. Next slide, please. Okay, so I've included at the end of the presentation the link to the code in case anyone wants to use it. I would encourage everyone really to have a read of it. It's easy to read, it won't take you very long at all. But what I think is useful about the code is what you're encouraged to do with it, and then actively to do with it. The first thing to note is that the code is voluntary. So whilst they say it always takes two to tango, in certain circumstances, I believe that it will help you to engage and open up a tenant to see what's truly happening in their business. And the purpose behind that is that, of course, you can then make an informed decision about what they're requesting. Now, I'm not going to read the entirety of what you see, the extract that you see on the screen there, but you see that I've highlighted part of the paragraph, and that is, landlords should provide support to a tenant where reasonably possible. Well, I guess that may be fine and dandy from a landlord's point of view, but you know, that needs to be balanced up. So if we move to the next slide. Now again, I won't read the entirety of the paragraph, but I've highlighted some passages which are therefore counterbalance. The expectations are that the tenant must have regard to certain aspects if they are to ask a landlord for a concession. So that may be being prepared to be transparent and explaining their request by providing financial information about their business. This should be appropriate and relevant. Now, the thing to remember is that from a landlord's perspective, you get a tenant and they're asking for some sort of concession or rent installment plan. What the code is saying is, you know, this is not an excuse for you to go on a fishing exercise to find out everything about the tenant, but you are able, by using the code, to say, well, you need to justify the reasons and to go behind it, and perhaps by quoting passages from the code. Once you've got the appropriate and relevant information, you're then obliged to give reasons if you decide either to turn down the tenant's request, or perhaps you can reformulate an alternative arrangement that's probably more acceptable to you and maybe something that your tenant can stretch to. But what I think is really important in how my clients are using the code is that as early as possible, you're engaging in a dialogue with the tenant. and you're able to elicit information. Now, why is that important? Well, they often say that communication is the key to any relationship. And so really the use of the code is to enable you to understand what's really happening with your tenant, as opposed to, I can't afford to pay, I don't have any money to pay. So that you, as the landlord, can make an informed decision and then plan accordingly. I mean, the more you trust the information that you're presented with, the more likely, I guess, you'll be able to generate a workable arrangement. And who knows, in this current economic environment, you might be helping to save a tenant's business and perhaps someone's job, and in doing so, and probably more importantly, preserve your own cash flow. Next slide, please. So just some quick tips at this moment in time to move things forward. So number one, commercial context. What do I mean by that? Well, I guess, you know, obviously have in mind the way that your portfolio is geared up and what it consists of. I mean, if you're in one of those rare sectors where even in today's market, space is a premium, you know, perhaps you're in warehousing and it's in demand in your area, or perhaps, you know, an industrial unit where people are scrambling around because they want to set up new PPE manufacturing facilities, or, you know, you own a portfolio where you have those out-of-town offices where people in the city are now relocating out, then, you know, have a think. If you've got a distressed tenant, you know, do you assist your tenant to stay afloat, or do you pop them? I mean, if they go, the downsides, of course, are all the commercial aspects, rental voids, marketing costs, rent-free invariably that you're going to be asked for, you're paying out on insurance, security, maintenance costs, and never far behind, of course, you've got business rates. And ideally, you don't want to let an asset of yours turn into a liability. Use the code to communicate, invite dialogue. When it's all over, you may end up with a more stronger and beneficial relationship with those tenants you really care about. If nothing else, the code should enable you to flush out those tenants who are simply chancing things. The other thing you can do when you're verifying and assessing your tenant's circumstances is that you might actually be able to point them in the right direction. You know, the government has a number of grants and scheme that are available. It may well be the tenant still hasn't taken full advantage of them. And that's something that we've been helping some landlord clients direct their clients, their tenants to do. Ultimately, always encourage your tenant to pay something. That would be my my thoughts on this. Better to have a few pounds in your pocket than none at all. If you do agree any instalment plans or concessions, get them in writing. If you are a landlord with debt and you're being squeezed because your tenants aren't paying, then of course, remember to speak to your lenders as early as possible so that you can arrange and negotiate payment holidays and so on. And finally, if you're unfortunate in a situation where you end up with a vacant unit, our experience has been with landlord clients, it makes a big difference if you can get a good local agent on board. They tend to understand the local markets, as they should do, but more importantly, you're looking for those little bits of advice as to, you know, what you need to do to the unit to get them lettable to the people that they think they can get in to view. Okay, so let's move on. Let's say you've done all the talking, it's getting nowhere, trust is breaking down. So what next? Next slide, please. Okay, in the good old days, if a tenant didn't pay rent, a landlord would instruct a bailiff, and the bailiff would go along, pay the tenant a visit, and if need be, cart tenant's goods away. Well, that all changed in 2014 when the whole area of law was overhauled and replaced by what you'll see there is CRAR, which stands for the Commercial Rent Arrears Recovery Regulations, CRAR for short. For our purposes, just note the following. As a result of the pandemic, there's been restrictions put in place under the Coronavirus Act So you've now got to have at least 189 days of rent outstanding. So funny enough, 2 quarters, before you can actually make use of the enforcement. So if you were up to date with rents prior to lockdown, which took place on the 23rd of March, you'd have to accumulate the whole of your March quarter's rent and the whole of your June quarter's rent before you can think of even instructing an enforcement agent. And when we're talking about rent, what we're specifically talking about is the actual rent element, not insurance or service charges or anything else. Next slide, please. There are other restrictions on this as an enforcement mechanism. I mean, you can't really use it on mixed use property. That's ones where traditionally you might have a commercial property which consists of a lock-up unit with some residential components apart, and that again, moves its usefulness away. So all in all, I guess, it's been watered down quite a bit, but still worth bearing in mind if you're in a situation come October and it is a viable option for you when discussions with a tenant are broken down and the only assessment is to make use of enforcement. Next slide, please. Okay, court proceedings. Again, there are restrictions about what a landlord can do. First thing, just to note very quickly, is that the landlord's right to forfeit a lease, the moratorium is then in place until the 30th of September. That may be a useful thing in some respects, simply because unless you've got a vibrant market, even if you did manage to kick a tenant out, who are you going to replace the tenant with? Now, so what we're really concentrating on at this moment in time really is taking court proceedings, because you can't pursue forfeiture applications, is proceeding to sue for debt, the rent as a debt claim. The first thing just to be aware on as a matter of practice is that courts themselves have obviously been affected by the pandemic, so don't expect any super fast response if you do decide to sue. I've mentioned the use of enforcement agents and how limited that is. I mean, effectively, you've got to wait for 6 months worth of rent arrears before you can even think about it. And then it only applies to certain types of property. If you've got a rent deposit, of course, you can draw down on that. That may give you a little bit more breathing space before asking for that to be replenished. If you're claiming against guarantors and you've got a situation where the tenant is guaranteed by surety guarantors, then now might be a good time, if you have a situation of a tenant getting into distress, to really shake that tree and put them on notice of any arrears. If you've got corporate tenants, you can issue a statutory demand, which is a method of kind of putting the frighteners onto a corporate tenant. But note that for the purposes of for this webinar and in this current environment, there are restrictions about presenting a winding up petition to collect rent or any debt actually up until the 30th of September, again because of the moratorium that the government has decided on aggressive action on tenants due to the pandemic. So in many ways, not much use in using that route in reality. So, I mean, the upshot of this really is this. Yes, you can sue for the debt. You can go through some of those items that I've mentioned. But what it really translates to on the ground is, as a landlord, you might be able to bark loudly, but your bite at this moment in time, unfortunately, will be a bit weak. So that really brings us on to why I think it's better to use the code and communicate and just to change stance, because I think the moratorium and the restrictions that the government has put in place and what your normal landlord remedies are means that you could be seen to be pursuing fairly expensive and potentially long-winded procedures that won't be bringing you very fast results compared to a normal environment. Next slide, please. Okay, so the scenario we're talking here is, what happens if you own a building and the tenant's business is one where restrictions to reopen have been lifted, but for some reason they decide that they're not going to reopen. But if that's the case, then they may be doing it for a number of reasons. But again, what we have to do is look at the actual lease itself. Most modern leases will contain a provision that will oblige a tenant to keep open, or keep open for defined opening hours. If you do come across a situation where a tenant is permitted to reopen under the coronavirus legislation, but chooses not to, could be, I suppose, the cost of compliance is prohibitive, or some other sort of health and safety reason, and wants to remain closed. What can you do? Well, obviously you can quote the provision. You could even, if you wanted to, go to court and try your hand at obtaining a court order compelling the tenant to open up. I think myself, the view would be to try and see what could be done apart from going to court. The reason being is that I think it might be hard to get a court order to compel a tenant to open up in this current phase and in this current environment. And that's assuming you can actually issue and get a court hearing date this side of Christmas. So I think, again, unfortunately, the current environment means we're just having to deal with the realities of what's happening. And a lot of my landlord clients are really concentrating on getting the rents collected and paid in first and foremost. Okay, moving on. Next slide, please. Okay, here we're going to whiz through some scenarios where a tenant might be seeking to escape the lease, and sometimes with varying degrees of self-harm involved for the tenant. First item I've got there is frustration. So I'm sure any landlord faced with a non-paying tenant is going to be frustrated to a larger or lesser degree. But what I'm actually talking about here is the legal principle known as the doctrine of frustration. In a nutshell, it's where you have an event, usually one which is unforeseen. So let's say, or not expected, the pandemic, which frustrates or interrupts the contract between the parties. So in our context, it would be the lease between a landlord and a tenant. So the argument would be, can a tenant relying on a global pandemic say, here you are, this has collapsed my business, these are good grounds for me to walk away from the lease? Well, the first thing to, and I've heard this discussed in the legal commentary and amongst colleagues, the legal doctrine of frustration operates within a really tight framework. And the common characteristics are, the issue needs to be unforeseen or illegal, i.e. you shouldn't be doing it anyway, and it renders the performance of the contract impossible. So, can that happen here? Well, I personally think it's a bit of a weak argument. Some of the arguments you can put in response are the fact that, the government closure order itself is fairly temporary when you think about it in the context of the usual duration of a commercial lease. And the fact is, now that they've lifted a lot of restrictions on many businesses, not all, but many, you can reopen up as long as you undertake the obligations to make it COVID ready, which is really observing health and safety regulations. So, I don't think, it remains to be seen, but I don't think a tenant's going to get much joy employing that type of argument. Moving on, break clauses. Of course, a tenant may be able to get out of a lease if it has the benefit of a tenant's break clause or a break clause in the lease, but that's a matter of timing. I mean, if it's the appropriate time and it just so happens to be around about now during this environment, then of course a tenant can exercise the break clause. I think the advice here really would be just to make sure that all the criteria relating to the way the break clause is triggered needs to be observed and fulfilled. Because if it hasn't, then as a landlord, it may well be that the lease is still intact. Moving on, we've got a number of insolvency type scenarios that I've listed here. And of course, you know, a tenant can of course go into insolvency or some insolvency process. The more serious ones being, of course, winding up, which will lead to the lease being terminated. But what you've probably seen more recently in the press are processes known as company voluntary arrangements, which is where tenants will engage an insolvency practitioner, and they'll try to restructure and re-gear some of their usually lease obligations as part of the administration, the arrangement. Now, there may be sort of very sound commercial reasons really to reach agreement with a tenant if these sort of scenarios come across. Primarily for a landlord, I guess, unless again you're in a scenario where you've got people beating down your doors to take your property. I guess it's just dealing with the fact that preserve some of the rental income, avoid empty premises, and then just move on and see what happens in the next phase that follows the current one. As always, you know, if you do come into these sort of scenarios, really, really important, any arrangements need to be recorded accurately so that everyone's intentions and understanding is properly understood and put in black and white, just in case someone doesn't hold up to their side of the bargain. Okay, yeah, next slide, please. Okay, we're on the home straight. This one, we're dealing with what happens in a scenario where you get a tenant asking you as a landlord to put in extra features or facilities or services due to COVID-19. Here's an extract of an email that one of my clients actually received, with redactions, of course. Anyway, the first thing to do is always look at the lease itself. Most service charge provisions in a lease, if that's the sort of lease that you've got, will set out what services the landlord is obliged to provide and what the tenant is obliged to pay for. Now, the ability for the landlord to recover the cost of, I don't know, anything from extra equipment or additional safety measures should normally be covered by that service charge clause, or certainly that's what you'll be looking for as a lawyer. The thing to watch out for is where the service charge might contain a cap on what the tenant is expected to pay. And that would be something negotiated usually at the start of the relationship before the tenant came into the unit and signed up on the lease. If that's the case, then of course the cap's going to operate. So if you are obliged to put things in and the tenant has the benefit of a cap, then unfortunately that may become irrecoverable. Another possible avenue to look at if you've been asked these sorts of questions by your tenants is to check the lease and see whether or not there's a catch-all provision. And quite commonly modern leases will contain these sort of provisions. And that's the one that says, you know, if the landlord incurs a cost or does something in pursuit of good estate management, then that can form part of the service charge provisions. And you might be able to then tuck in any of these extra measures and costs and expenses into that, and then pass that down on to your tenant. Okay, so we've done a quick tour of some of the more common themes that we've been fielding as a department, and you know what might work and what might be dead ends in the current phase. I think that most people I speak to want things to go back to normal. I suppose you, like me, probably want that as well. And I've talked about the code, which I referred to earlier on, for a reason. What you'll probably find is that a lot of the legal avenues that normally would be available to a landlord have been blunted or curtailed by the government. And so really you've got to use something else to try and get yourself back into a constructive position. Now I've noticed that actually whenever we've used the code as a landlord to engage with a client, a tenant as early as possible, the communication starts a process, if it's undertaken carefully and properly, of enhancing really the thing that glues most things together, on top of the legal provisions, of course, the enforcement side, and that is the glue of trust. To get back to normal, we want tenants paying their rents and on time. And if we are to get back to normal, I guess everyone needs to play their part. And the more you trust the other party, I guess the more likely you are to play your part as well. So that is the information I wanted to cover. And so if there are any questions, then I'm happy to answer a few.
That's great. Thanks very much, BJ. We did have a couple of questions put in advance of our webinar today, so I'll ask you those first. The first one is it illegal to chase for unpaid service charges?
No, it's not. There's nothing in the regulations to say that that it's illegal for a landlord to chase. In actual fact, there's nothing in the regulations to say rent is, it can be excused or ceased or any of the other provisions. They are payable as normal in actual fact. So no, it's fine to chase. But what you can do about it's the enforcement side of it, which has been blunted by a lot of the legislation. That's the issue for most commercial landlords. Okay.
And actually, to follow on that, we've got a question here from Julia. Can a tenant withhold service charge if they are not using the office?
Again, it's to look at the precise terms of the lease. I would have said, on the face of it, probably service charges are still due. And one reason is because the use of the office is really, well, put it this way, in the current environment, it's possible for people to go back to the office and use it. I think it's slightly different if you're subject to a mandatory closure, but even then, to suddenly cease all your payments is, I think, a bit of a sticky wicket to pursue as a tenant. So I would say, on the face of it, if a tenant's not using the offices, that's not an excuse not to pay the service charges. It may well be that they can argue the service charges should be low. I mean, I've heard that argument, which is, people aren't using it, so, there's less gas, electricity, water, and, security. I've heard that argument being employed. But that's more about the amount of services being consumed, which is fine, rather than, no, point blank, I'm not paying a penny.
Okay. And I've got a final question here. Do we have to give rent concessions?
No. Again, I think any landlord needs to just review and have a look at the scenario that they're presented with. If they choose to for commercial reasons, then yeah, that's fine. I mean, that's a commercial decision for that individual landlord. But there's nothing in the regulations to say you must, give up rent, or you must give people time to pay, and so on and so forth. But I think, if one were to use the code, then, where you have genuine circumstances as a landlord, and you're seeing that, well, the tenant has given you information, you're able to assess the information, you trust what the tenant is saying, and you can work together with that. Maybe you can have an instalment plan and make sure that any arrears currently are brought back up to date, with or without interest. And that might be a workable way forward.
Okay, excellent. Well, that brings us to the end of our webinar. Thank you very much for the presentation, BJ. We have recorded this session, so we will make this available on demand if you wish to re-watch this webinar, and we look forward to our next one. Thank you very much.